What is a severance pay clawback? In an effort to break down the legal complexity associated with an employee's termination letter, which is made all the more difficult by having lost one's job, we look to provide you with an understanding of various aspects that might arise in the termination letter that employees receive when fired, terminated, laid off, or otherwise forced out of their job. In this particular video, we will be looking at the concept of a severance pay clawback, which is not found in all employee termination letters. However, when it is written into the document, it does demand serious consideration and understanding. A severance pay clawback is a condition imposed by the employer on the fired employee's receipt of the proposed severance pay, with a contractual arrangement enabling the employer to reduce the total amount of severance pay paid out should the fired employee find comparable replacement employment shortly after their termination. The structure of the clawback typically involves severance pay being paid out in monthly installments, oftentimes over a 6 to 12 month period, with the indication that the fired employee is to seek comparable replacement employment. And should such employment be attained, oftentimes established where the new employment meets a threshold percentage of the departed employee's prior salary, the remaining severance pay installments from that point forward would be reduced by a set percentage or eliminated in their entirety. In addition to placing an obligation on the fired employee to seek comparable replacement employment in a timely manner, this contractual arrangement tends to place a positive obligation on the fired employee to promptly report the retainment of new employment and reduce their receipt of severance pay from that point forward. As the following example illustrates, employers can have considerable incentive in having a severance pay clawback followed, whether it is to recover a portion of the originally offered severance pay or keep their former employee away from their competition for the duration of the severance payments. For example, the termination letter sets out severance pay in an amount of $140,000, payable over 10 months at $14 at the end of each month. The clawback provision states that if the fired employee finds comparable replacement employment that pays at least 80% of their salary with their former employer, they would only receive 50% of the remaining installment payments. Now, if the fired employee starts a new job after 3 months, which pays at least 80% of their prior salary, they would have received 3 payments at $14,000 apiece, with the remaining 7 payments being only paid at $7,000 apiece, meaning that the resulting severance pay is only $91,000, such that the employer is achieving an effective saving of $49,000. As this is a contractual arrangement, it is legally viable in relation to common law severance pay, provided that it does not delay the payment of any statutory amounts, which have a very short timeline within which full payment must be rendered pursuant to the applicable employment standards legislation. That means statutory termination pay, vacation pay on termination pay, and statutory severance pay in Ontario must be paid in very short order, with each employment jurisdiction having slightly different rules. Although courts have permitted severance pay clawbacks when done correctly, their inclusion into a termination letter can also be the basis for a legal challenge by the fired employee, especially where there are other factors that are available to a fired employee to optimize their payout on termination. For when an employer is seeking to undercut payments to an employee, it can be indicative of efforts to reduce employee payments in other areas. If you have received a termination letter and question the adequacy of your former employer's proposed payout, contact us for a free confidential consultation to discuss your options. Thank you.